Patrick is the Senior Vice President and Chief Intellectual Property Counsel at Warner Brothers Entertainment. He has a long and impressive bio, more than I can give credit to with this introduction. I'm not going to force you to listen to me read his bio, which is in your program. I'll just say that Patrick has a very, very impressive educational and professional credentials, and we're so lucky to have him with us here as our keynote speaker. And on a more personal note, I understand he has family in the area, so I'm claiming him as a adopted Utahn for the purpose of this event, and we'll just see if we can make that stick. So make a good impression, everybody, and don't embarrass Utah by asking impertinent questions or anything like that. All right, so if you'll please join me in welcoming Patrick Perkins to the stand, and we'll look forward to hearing his remarks.
Well, it's great to be with you. Peter's right. I do have ties to the area. I have a daughter who is just started as a freshman at another university in this same metropolis. We dare not speak its name, and she's loving it so far. And I guess I can admit that my father was born and raised in Utah as well, and I spent many a summer here as a young boy fishing in the Uintas. So you got to put that as an excursion on your next trip, Peter, is a fishing trip up the Uintas. So because I'm from a motion picture studio, I'm going to do what motion picture studios do. I'm going to start with a sizzle reel. So let's hope this works. Well, thank you very much. That is the high point of the presentation. It's all going downhill from here. I'm really grateful to be here and grateful for the opportunity to have had to think about a few issues to be able to share with you. And I've entitled my remarks today, 3 Things That Keep Me Up at Night. And I've chosen 3 topics that are disparate, and with the hope that one of the things I'll be able to convey to you is that the thing that keeps me up at night is lack of certainty and lack of predictability. And that's a lot of what we are finding in our space. That comes with some good news. It's a full employment plan for many people in this room, but it also makes it difficult sometimes to plan, and it's causing your clients or large companies or small companies to try to figure out how to pivot in this sort of changing landscape. So I want to take a few minutes today to talk to you about these three areas. And the first one that I want to talk to you about is the EU Digital Single Market Resolution. So I've been to these things before, and I have done what many of you may be doing right now. You start to see that there is something that is non-US, and your eyes start to glaze over. You start to think, why do I have to hear about this? And here's what I'll tell you. These are going to be the vegetables of the presentation today, okay? It's good for you. It's important to know what's happening in the rest of the world, particularly if you are advising global clients or are involved in what's happening around the world. And the thing to remember is that copyright, as well as trademark, as all of these schemes that we have, they are all territorial, right? And every territory has their own scheme, and you have to be familiar with what's going on in those schemes and recognize that they are being treated differently in different countries. This particular issue, the EU in 2015 started this project essentially to try to encourage the free movement of their goods and all the stuff that they were supposed to get from being part of the EU. And as a result of that, they basically came up with these 16 initiatives. Some of them are regulations. Regulations from the EU are immediately in effect. They don't go. They pass go and they go straight to the $500, right? They don't have to go to the member states. Directives, on the other hand, have to be implemented in each of the member states. And you can see the purposes that they hoped to accomplish with that. And so what I want to focus on today, there are many of them. I want to talk about the copyright directive that's related to authors and performers, because I find that one to be the most interesting and also the most potentially disruptive. So it was just entered into in June of this year and has an implementation deadline of June 7th, 2021, which means that every single one of the member states in the EU has to pass their version of what is in this directive. And the directives aren't so much statutes as like suggestions. They're sort of like principles, and they, in typical sort of political fashion, they just say, "Here's what we want you to accomplish. Now go do that." And then some smart people sit in a room and try to figure out how to do that, and then a bunch of companies like ours and others go and lobby and hope that the damage is not terrible. So the first thing, the first one that I want to talk about, I'll lay out what these are first. The right to appropriate and proper proportionate remuneration, the right to transparency, the contract adjustment mechanism, what we in the industry have often called the bestseller clause, and the right to revoke. So these are the four things that are in this copyright directive that I want to spend a little bit of time talking about today. The right to appropriate and proportionate remuneration. This is directed at authors and performers. Now, who could be against appropriate and proportionate remuneration, right? That is like, everybody wants to be paid fairly. That's what everybody wants. The question is, what does it mean? How do you implement something like that? What is that going to look like? Here's what the EU tells us. First of all, they're telling us it's only going to apply to exclusive licenses and transfers. They're telling us that the implementation has to take into account the following. The member states are free to use any different mechanism, so how they figure this out, how they determine it, how they enforce it is going to be completely up to them. They have to take into account the notion of contractual freedom, whatever that means, because they then will tell you that you can't contract away certain rights, right? And they have to balance the rights and interests of everyone involved. Isn't that helpful? Now go off and implement with that strong and direct guidance that you've just received. So this is something that already exists in many of the member states, and the way that it's been applied has been sort of disparate, right? For many years, for example, deals that were being made with performers and authors tried to deal with specific uses in those agreements. Then you saw more of a buyout kind of approach in agreements. To my knowledge, this has not really been litigated very much, if at all, in the EU, and it'll be really interesting to see sort of what the member states do with this and what they try to do to implement this. The second thing is this notion of a transparency obligation. Now, this is the one that is really sort of really difficult to try to figure out. And I've put the wording on here. I won't read it to you because I really love it when people read from their own PowerPoint presentation. I don't know about you. It's my favorite thing. But essentially, this transparency obligation places upon people who exploit copyrighted works an obligation to report. And that sounds okay, right? Except that in certain industries, reporting lines have already been established. And there are certain people who get reports, usually people who have some kind of a back end or continuing revenue right, whereas people who don't generally don't. Now, the EU is saying potentially everybody needs to be reported to. The question is, what are you supposed to report to them? Well, your guess is as good as mine. One thing, however, is that this transparency obligation has to be imposed on sub-licensees. The primary licensee or transferee of a right has to be the one has to cooperate essentially and give information as to who the sub-licensees are. And they have to, the member states are now going to have to decide whether there's going to be a single point of contact, which is the initial transferee, or who will then have to gather all the information for all the sub-licensees, or on the other hand, whether the folks who are seeking reporting are going to have to go to the various sub-licensees. The obligations under the directive must be proportionate and ensure a high level of transparency. So I think in the dictionary, next to the word tautology, you have a transparency obligation that has to ensure a high level of transparency. And again, I don't mean to make light of this necessarily, because I do think that the goals that are being pursued here are good goals. But the devil's in the details, and the ability to kind of figure out what it is that as an exploiter you are going to have to keep in order to be able to report that is totally unclear. And even in jurisdictions where this has existed, so for example, Germany has had this in their copyright law for some time. When you speak to German counsel, they don't really know what it is that you're supposed to be keeping, what kind of information you need to share with them, nor do they tell you whether that obligation should be limited to exploitation in the member state or whether it should be beyond. Here's sort of where the EU giveth with one hand and taketh with the other, right? It says the obligation has to be relaxed where it's disproportionate, or when you have works that are created by multiple people, you can't have the tail wagging the dog, right? So you can't have one contributor hold up the entire thing and make it so that essentially a company is having to report to sort of somebody who did one thing on one day on one movie, for example. And finally, they've injected into this the notion that arrangements that have been made through collective bargaining can sometimes be imported and be used as the transparency, as the metric for what you need to show and when you need to show it. That's a theme kind of throughout these directives. So a related right is this bestseller right? So this is by virtue of having used your transparency right, a performer and author actually has the right to go back and say, you know, this did way better than we ever thought it would, so I think that I ought to get more money. So in a lot of instances, again, this has been the law in Germany for some time. In Germany, again, collective bargaining setups, ongoing payment obligation setups, those kinds of things have really sort of substituted and been found to be essentially satisfactory in this kind of a situation. But now that we've got kind of a reboot throughout the EU, we just don't know what this is going to mean and how it's going to work. So let me give you just this one example of how this played out in Germany. There was a case on the bestseller obligation involving a dubbing artist. Now, interestingly enough, a dubbing artist is somebody who's not going to get a back end, right? It's somebody who's going to get paid once for their thing, and then that's it. It's a buyout. In the case of Pirates of the Caribbean, this is a movie that did reasonably well, and the court found that it was viewed by between 300,000 and 450,000 German-speaking folks in the territories, and so it was over average success. I don't know how they determined that, but I think the courts came to that conclusion. And the artist received an additional 67,000 euros, which, for him, was a lot of money. For the studio, probably not a lot of money. But the thing that's relevant, I think, to look at is it was 15 times the normal rate. So again, this is a concept now that's going to expand beyond Germany and go to the rest of the European the European territories. But here's my personal favorite, and that's the right to revoke. So we have in the United States, obviously, a termination scheme, a legislative termination scheme under copyright, the copyright termination scheme, both under 304 and 203, and in addition to that, within certain industries, particularly the publishing industry, there is essentially a right to revoke. Essentially, you in many publishing contracts, when a publisher, when your book is out of print, you have the right to go then contractually to go back. Many of the publishers will give you that to essentially get those rights back, where the publisher has squeezed everything out of it that they think they're going to be able to get. The author says, I think I can get somebody else to buy this book, so I'd like those rights back. Oftentimes, not always, publishers will have that mechanism in the agreement. So this is that sort of notion, but on steroids, right? So there are two things, and again, this exists in the German scheme, but there are a couple of things about this that are problematic in terms of how to draft it and how to make it work. So this is not just limited to authors. This also refers to performers. So in the example that I gave you before with books, pretty easy to see how that would work, right? You've had a publisher who's had a book that it's out of print, they're not publishing it anymore. They've sort of exercised the right. The author comes back and says, I want it back. Publisher says, yeah, fine, you can have it back, and they revoke. But what about a situation where an underlying work is a book that's been licensed to a movie company to make a motion picture? So in the first instance, if they have the book and they don't make the motion picture, pretty easy, right? You can go back and say, you now have 6 months, otherwise I'm going to take this back. But what if the rights that were granted were not just the right to make a motion picture, but also the right to make sequels and remakes? So the motion picture studio has made the motion picture, marketed it, licensed it, done the whole thing, still in somebody's library. The author of the underlying work then has the right to come back and say, you haven't made a remake or you haven't made a sequel, I want those rights back. That's foreign to us, right? I mean, that's something that would never happen under in a U.S. scheme, and so that's something that would be that people are going to have to deal with. But what makes it even more complicated, in my view, is extending this to performers. It's not clear to me how a performer can revoke the right to their performance, because that performance that's already on a motion picture or on a CD has no value disembodied from the CD or the motion picture. So it's hard to understand how that's going to play out, and we're all very curious to see how the states actually implement this. So the only way that this right to revoke can be derogated is if it's derogated through a collective bargaining agreement. So again, the notion that the only way that the performer or the author is viewed as having had sufficient bargaining power to know what's going on is to have that right derogated through a collective bargaining agreement. Again, super interesting in my view. So if we take into account, the states have to take into account the following things. They have to take into account the sector, the different types of works. They have to look at multi-contribution works and the importance of the contribution. So again, if you think about a multi-contribution work, and I'm biased because this is what I work in all the time, an audiovisual work, a motion picture, a television show, you have a number of different creators, right? And so again, what happens if one of the creators wants to revoke but nobody else does? How do you deal with that? Is that even fair? And I think the EU sort of recognizes that when they say that you've got to take that into account. And they do give the states the right to exclude works that are multi-contributor works. All of these things require specific time frames. In other words, a specific period of time during which the period before which or after which somebody can actually revoke, and also needs to provide a notice time frame as well. that's reasonable, and that's one of the things that the EU is indicating to the states. So the authors and performers also are being given the right, or if the states so implement, to just revoke the exclusivity piece of it, which is also kind of an interesting thing, right? So if you have licensed your book and a movie has been made, and you say, you know what, I want to see another movie made, I want to see it made by somebody else, so you can keep your non-exclusive right and you can keep exploiting the movie, but I want to take these rights back and now give them to somebody else. Query whether, if you bought these things on an exclusive basis initially, how you feel about that once you've invested millions and put your movie out. And then just because you're not making a remake or a sequel, somebody can change that to a non-exclusive grant. Again, super interesting in my view, and we're all watching very closely what the EU states do in the next couple of years while they implement this. The thing that I worry about is an amplification of what we have now, which is a disparate set of rules across Europe. And part of the issue that we've had, and we've avoided, frankly, making content in certain countries because of those different rules. But the reality is that because copyright is territorial, even if you don't make the thing in a certain country that has stringent rules, in certain instances it will not stop someone from exercising their right under that jurisdiction's laws. Now, at the end of the day, if I own the rights in 100 countries, and somebody sort of gets their rights back in one country, even in a relatively major country like Germany, the incentives to do that are not great for the author and are not terrifying for a media company. But by the same token, it's really going to be interesting to see sort of how this plays out and what's going to happen. So that's one piece of the EU directive. There are lots of other pieces that are relevant to the industry, including having to do with cable and satellite transmission. I thought that this was the most interesting, and I thought you would definitely be asleep if I started talking to you about cable and satellite transmission. So let me move on to the second thing. And I want to talk to you about deep fakes and our really good friend, Kim Kardashian. How many of you here have ever heard the phrase deep fakes before? Do you know what that is? So it's essentially fake video. The term deep is used because it refers to deep learning. Over the last couple of years, there have been incredible advances in AI technology that make it even easier now to create sort of very convincing but fake video. I'd like to play for you this video, which is
when there's
fake.
So many haters, I really don't care because their data has made me rich beyond my wildest dreams. My decision to believe in Spectre literally gave me my ratings and my fan base. I feel really blessed because I genuinely love the process of manipulating people online for money.
It's kind of remarkable, isn't it? It looks totally real. This is a deep fake video. And this is both an exciting technology but also a terrifying technology, particularly as we live our lives more and more with screens and online, and that's the way that people are getting information. It doesn't take long to start to think about sort of the ways in which these things can be misused. Legislation has started to appear and to combat the most sort of egregious ways in which this has been used. And really the most nefarious ways to date have been celebrity pornography, so essentially taking pornographic material and putting the face of a celebrity on it. And so it seems like they have willingly participated in the pornographic film, or political misinformation, to have political figures, candidates, and the like say things that they did not say, or say things in a way that they did not say them. And we've already seen that. That's been happening, and it's only going to get worse because the technology gets better and easier. So California has passed, and it was just signed into law last week, AB 602, which is I think the first deepfakes legislation, the statute in the country. It flows out of the right of privacy, and essentially it relates solely to the release of sexually explicit audiovisual material. But interestingly, not just fakes, right? So this is also the porn tape that somebody made when in a relationship and didn't give permission. So that's also kind of swept into this. But the real news from an IP perspective is that we've now we've expanded the right to privacy to include this notion of these deep fakes. They've also passed AB 730, which is in the election code, and essentially it's again directed at this second prong, right? The second thing that people are doing. These are these political ads that are materially deceptive, and so within 60 days of a campaign, you can't you now in California you cannot disseminate materially deceptive audio or visual media. There are significant First Amendment concerns, obviously. Some of these things can be used for commentary, and I think a lot of us are really watching to see how that goes. Now, why deep fakes? Why do they keep me up at night? Deep fakes keep me up at night because they have become a gateway for other legislation that I think is problematic for the storytelling industry, and that is legislation that relates to what we call digital avatars or digital replicas. So part of what's happening with this technology is that we can depict just about anybody doing anything, right? And that would include a celebrity alive or dead. Now, most of us would feel like, well, gee, I don't feel like I ought to let somebody use my likeness in a way that I don't approve of. And yet, we already have that scheme in play with regard to biographical materials, right? So biopics and even sort of fantastic biopics. And so what's happening is that what you see is that the deep fakes, this is my sort of theory, and I probably should have started by saying everything I say is my opinion, not opinion of the company, blah, blah. You know that stuff, right? But this is sort of my theory as I've watched this sort of unfold, is that the digital avatar right is an outgrowth of the deep fakes hysteria. And what's happening is what they're trying to do is they're trying to take that digital avatar, the deep fakes, turn it this digital avatar right, not have it be a privacy right, but instead flow out of the right of publicity. And what's the problem with that? So the right of publicity typically has been cabined to commercial speech, right? Everybody can agree that I should not be allowed to use Peter Midgley's picture to sell this bottle of water, right? Shouldn't be allowed to do that. The question becomes, if I decide that my next big idea is to do a biopic about, the BYU licensing operation, should I be prohibited from using an actor who looks like Peter Midgley to play Peter Midgley in the role of Peter Midgley in the biopic, right? Should I be kept from doing that? The First Amendment, as long as it meets the newsworthiness sort of requirements, would say no, right? The First Amendment protects expressive works. And what's happening with right of publicity is really two things. One is that you have a number of states that are now passing these laws and providing this right as a post-mortem right, which is relatively new, which I think most people are fairly comfortable with, provided there are exceptions for expressive works, right? But what's happened with this digital avatar right is it's going the next step, and I'm going to use as an example for you a bill that did not pass the Louisiana legislature this year, lost by one vote. It was a digital replica, and what it meant was a computer-generated electronic reproduction of an individual's likeness or voice, right? It defined a performance as a use of a digital replica to substitute for a performance by a professional performer. right? And then sound recordings and audiovisual works that contain the unauthorized performance were prohibited. So here is what people who are proponents of this were sort of getting at. What they wanted to make sure that we, the movie industry, couldn't make Mission Impossible 25 with a digital avatar of Tom Cruise. And I think most people feel like that's fair, right? And from an employment standpoint, the notion that I can decide, you know what, Tom Cruise, you're getting a little long in the tooth, you're super difficult, you only want those green M&Ms in your trailer, I'm going to just make a digital avatar, and I'm going to use him to be you, and then I won't have to pay you anymore, and I don't have to deal with the green M&Ms anymore, right? That's the argument, and it's not a bad argument. So what they're saying, the proponents of this, is we just want to prevent the use of a replica that plays a fictional character, right? So that's the Tom Cruise example, all right? And here's what the legislator said at a hearing. And notice what he chooses as his examples. This is Louisiana, remember. He says, I don't think the family of John Wayne should have to endure a biopic or a motion picture in which John Wayne's avatar is being used to play the Jake Gyllenhaal character in Brokeback Mountain. Now, I was really glad that I was not in that hearing because I would have loved to say, Senator, I just want to understand why this example? Because I'm not nice like that. But look, that's the example. And the other example that I've heard said in meetings is a movie studio ought not be allowed to use the image of Heath Ledger to play Jack Sparrow in Pirates of the Caribbean 7. Or are we up to 7 now, 9, 12, whatever we get to, right? And that's a really compelling argument. Here's the lobbyist argument. If you swap in Michael Jackson for John Wayne, or Bill Cosby, or name your other sort of entertainer who is not sort of revered and viewed as an icon, and that's being done because the filmmaker is trying to make a point, is trying to tell the story that she wants to tell, at that point, it becomes a more complicated and difficult issue. So even this line where you say we don't want them playing a fictional character. So one of the examples that some of the group that I work with have talked about is the movie My Weekend with Marilyn, which I've never seen, but apparently follows a week, or My Week with Marilyn follows a week where she essentially walks off the set of a movie that she is making with Laurence Olivier because he insulted her. And so under the fictional characters example, if I'm making a biopic about Marilyn Monroe, so I'm okay with Marilyn, right, because she's playing herself, except if I show her in a scene with her acting partner, Laurence Olivier, playing the character in the movie that she walked off of, at that point, she's playing a fictional character. So it creates these new, interesting, difficult constitutional issues. And the thing that keeps me up at night about this is that biopics have become more and more and more a part of what consumers want. They crave these things. I'm working on 2 or 3 right now, including a big Baz Luhrmann sort of Elvis Presley movie, right? So this is the thing that people want, and that filmmakers want to really be able to tell these stories. And if you take the notion that there's absolutely nothing that prohibits a filmmaker from taking an actor who looks like Elvis Presley to portray Elvis Presley, then why should it not be okay to use a digital avatar to increase the realism? to suck the viewer even more into the story. Those are the competing concerns. Those are the things that you worry about. And really where this heads, and the place that you get really concerned about, is that heirs, or worse, corporations who own rights in somebody's likeness, particularly someone who has passed away, have a censorship right. Right? So easy target, right? But if you decide that you want to make the Donald Trump biography, right, and you want to use a digital avatar, including his star turn as Waldo's dad in the 1994 Little Rascals movie, you're handing the Trump family a censorship right. Super interesting, super difficult issues, things that are going to be cropping up time and time and time again, and again, uncertainty abounds. And these statutes that are being proposed, many of them are not written very well, and they really do create sort of more questions than they answer. So again, lack of certainty. Don't know how this is going to go. Don't know how we clear a biopic, which, by the way, is hard enough as it is, that gets way harder. So that's thing two. Deepfakes and digital avatars. All right, time for dessert. Copyright fair use. So first of all, to those of you who were in Professor Abdul Khalik's session earlier, she did a great job with this, and I want to just sort of, fortunately, what I have to say is complementary but not duplicative. So I'm hoping at least that that's the case. So I chose this case. This is a decision. It's the posture is very early. This is Dr. Seuss Enterprises against Comic Mix LLC. It's in the Southern District of California. It's in the district court level, and it was at the motion to dismiss phase. So, but to me, it's emblematic of how fair use has become totally unpredictable and unhelpful if you're a practitioner on either side of this issue, which we are on both sides, right? So we sometimes will want to use fair use when we are making something. Sometimes we are defending against a claim of fair use when somebody has appropriated something that's ours. And so this is, this has become a little bit of a hobby horse of mine. In this case, to me, is sort of the emblematic reason why we're in so much trouble. Now, here, everybody knows about the factors and the preamble, but I just put these up here so that everybody can see them. The preamble is going to be an important part of the point that I'm going to make, but you can see that the statute basically says that fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, including multiple copies, scholarship, or research, is not an infringement of copyright if, and then it goes through these four factors that if you look at. So here's sort of what happened in this case. The court on factor one, and we'll talk about this, that held importantly that this new work, so let me go back, this work, I'm like assuming that everybody knows this, hold on. So on the left-hand side is this well-known Dr. Seuss work. Oh, the places you'll go. If any of you have kids, you've probably read it to them 1,000 times, and for some of you it might be triggering and say, please, I don't want to hear that one more time. On the right-hand side is the book that was put out by this Comic Mix LLC without permission from either CBS and Paramount or the Dr. Seuss folks. Oh, the places you'll boldly go. Right? It's sort of that split infinitive was the big thing, to boldly go where no one has gone before. That was the big thing in Star Trek. For those of you who don't recognize that, that is a Star Trek ship on the right-hand side. And so what happened was Seuss has sued. Comic Mix makes a motion to dismiss. And the motion to dismiss on copyright grounds is based on fair use. So now we can head back to the decision. I'll just go through it really quickly. The court weighs the four factors. Importantly, they find that the new book is not a parody. Keep that in mind. It's a very important point. Again, Professor Abdel-Khalik did a great job explaining this, and she was right on. They said it's for profit and it's transformative. In factor 2, it favors the plaintiff, but it doesn't matter, as is often the case. Factor 3, it copies many aspects, but not in their entirety. They haven't taken more than they need. I mean, it's sort of this amorphous, hard to sort of understand factor. And then factor 4, this factor that we'll talk about, presumes licensing opportunities, but those are neutralized by defendants' work being so transformative and not a substitute for the original. So, ultimately, it denies the fair use motion. It's a bizarre decision. It's like it's an exercise in like feudal dicta, that they just pages and pages of this and say, well, I deny it right now because it's an early posture and there are too many facts and we need to come back to it. I'm like, well, why? Why did you do this? But in any event, that's sort of where it is. So I want to talk about the first factor, and the first factor in the statute is called the purpose and character of the use. And the question is, where did we go wrong? So in the good old days, this factor was commercial versus non-commercial, right? And the Supreme Court in the Sony Betamax case even said, look, if it's commercial, you have a presumption of market harm. That's not necessarily right either, but that's kind of where we were. It fits comfortably within the statutory categories in the preamble. That's the piece that I think is critical. Before the stuff I'm going to talk about in just a second, the preamble kind of ruled the whole analysis. That's where you looked to see whether or not something fits in to being fair usable. And then other things like the work is a serious book of responsible criticism. Those are all quotes from earlier cases that would analyze this particular factor. Here's where we go wrong. Our good friend Pierre Laval, who's now a judge in the Second Circuit, at the time was a district court judge, didn't like the way higher courts were reversing him on decisions on fair use, and decided to write this article for the Harvard Law Review to be helpful and to provide what he thought would be what the courts needed in order to do a better job on fair use. And in discussing factor 1, he really does two things that I think that change the landscape of fair use. I won't say forever because the pendulum appears to be swinging back a little bit, but significantly. The first is he totally ignores the preamble, reads it out of the statute. Instead, what he says is, does this use fulfill the objective of copyright to stimulate creativity for public illumination? So that's a reference to the Constitution, where the Constitution creates the exclusive rights for copyright for the purpose of advancing learning and public interest and everything like that. Now, until 1990, in the copyright sphere, that notion had typically been viewed primarily to be the incentive for authors to write. Right? So that was the answer to the question. How does copyright advance civilization? It incentivizes authors to create and rewards them with exclusive rights. But now he extracts that, and instead what he does is he says, the Constitution really just talks about good for the public, right? And yes, this notion of an exclusive right may be one of them, but there are many others. Second thing, he introduces this concept of transformativeness. The use must be productive. It must employ the quoted matter in a different manner or for a different purpose than from the original. Seems completely innocuous. So here's what happens. We go on. Acuff Rose case, they adopt it. The court, importantly though, and the professor made this point at the last session that I thought is exactly right, the court made a determination at the outset that the song was a parody. And essentially that the parody was within the ambit of the preamble. The court holds, look, the preamble is a non-exclusive list, but they make that point because the word parody doesn't appear in the preamble. That's the point they're making. That the preamble is still supposed to be instructive. It's supposed to tell us the ambit of the kinds of works that are supposed to qualify for fair use. The court held that the song was a parody within the spirit, and then transformative. Again, this notion of transformative was not meant to be a substitute. It was meant to be additive. It was supposed to be, not only does it fit within the preamble, but it takes something and adds something new, right? It's actually a pretty good decision. It's just been misused. So where did we go wrong? Here's the transformative language, and here's the nub of what the problem with transformativeness in fair use, and why it's led to some really wacky decisions. Here's the language for transformative, right? That's a quote from Judge LaValle. Now, I defy anyone to explain to me what the difference conceptually is between that and the definition of a derivative work under the Copyright Act. What's the difference? It is just, there has to be something more. It can't just be, well, it's transformative, therefore it's fair use. Because every derivative work is going to be transformative. So I didn't come up with this on my own. At least one court in Seventh Circuit actually, in referring to Carry You, the case that was discussed, this is the absolute nadir of fair use decisions ever, says, look, we're skeptical of this approach because what's the difference between transformative and a derivative work? I mean, that's essentially it. And so, a couple of examples, right? So on the left-hand side, there is the first appearance of the Joker in Batman, and on the right-hand side, the most recent movie with Joaquin Phoenix. I can guarantee you it's transformative. It's also an authorized derivative work. I am sure that any filmmaker, if I go back to the language, would say it doesn't supersede the original creation. It adds something new. There's further purpose. There's different character. It's telling a different message than the first one. That's what people who create derivative works want to do. And so again, it just points up the kind of the absurdity of disambiguating transformativeness from the preamble. One more example for you. Right, Captain Marvel on the left, the first appearance of Captain Marvel. On the right-hand side, the most recent version, Captain Marvel. I would say transformative with a capital trans, right? So it's, totally, right? Completely different. So let's talk about the fourth factor. The fourth factor, so this is this market harm. The factor has been held in the past to be the most important factor, that the Supreme Court and Sony said it was market harms presumed. The Supreme Court even holds in Acuff Rose in the Pretty Woman case that the harm of market substitution, including for derivatives remain of concern, but that if it's a parody, and through that parody it affects the market, through the criticism it affects the market, that's not relevant. That makes total sense. If you are commenting on something and your commentary, is First Amendment protected commentary and it trashes the original, that simply cannot have an impact on whether or not it's fair use or not. I get that. That makes perfect sense to me. That is not what happened here. So let's go back to the Seuss analysis. The court looks to only the particular harm, but whether not only the particular harm, but whether the unrestricted and widespread conduct would cause serious adverse effect. So, what do you think? If you're Dr. Seuss Enterprises, and anybody who wants to can publish a competing book with Dr. Seuss and mash it up with something else, is that going to harm the market? particularly if you have a licensing business, which the evidence showed that they did? I would say yes. But again, the court says, there's this presumption of harm is neutralized because it doesn't substitute for the original. Fair. Just like the example that you gave, Professor, I'm not going to go out and not buy Pretty Woman because I decide I want to buy the 2 Live Crew version of Pretty Woman, right? I'm not going to not buy the Dr. Seuss book because I'm going to instead buy the other book, fair. But I will tell you, it's equally true that I'm not going to not buy Action Comics #1, the first Superman story, simply because I can buy the movie, the Superman. That cannot be the analysis. It makes no sense. The court identifies in this case what it regards as the emerging mashup culture. Like a caveman who has discovered fire, this judge has discovered the emerging mashup culture. Really? If only there were examples of mashups in the world that pre-existed this. Say in 1977, where we mash up Wonder Woman and the Bionic Woman. Maybe it's just a Star Trek thing. Maybe it's because it was Star Trek. Oh, yeah, wait a minute. Done already. Yeah, if only there were evidence of mashups that were common in our culture. That would be awesome. If only. God, I wish we could find some. I really do. So the good news is that this case, as I said, she denies the fair use. The judge denies fair use, and I think it's going to get a lot of attention, and I think it will get righted. But this case is emblematic of we have a problem in fair use. It's become a judicial Rorschach test. And transformativeness has become sort of the key to finding whatever you want to find. And it's a topic. It's a concept that's just not helpful unless it is coupled with the preamble of the Copyright Act. So let me just conclude by saying I still sleep like a baby. But these things do bother me, and it's the lack of being able to predict and to plan and to advise that makes all of these developments and more really sort of challenging, exciting. I think that if I were 15 years younger, I'd probably sleep better. But it's an interesting time, and the landscape is constantly shifting. And so I hope it's given you a little bit of an insight into some of the things that we deal with, and that has been at least remotely instructive. If not, I know there's more cake at the back of the table to make everybody feel better. So thank you very much.